My name is Stephen Minnis, and today I'm joined by Professor Colin Scott. Colin Scott is Principal at the University College Dublin College of Human Sciences, as well as Professor of EU Regulation and Governance. Colin Scott, welcome.
Thank you.
Multiple fields these days have private regulation as well as regulation by public authorities, whether that's governments, whether that's the EU or others. How has this state of affairs come to be?
Well, in many of the markets we've looked at in research on transnational private regulation, we've observed sectors where the public rules have, for a variety of reasons, proved insufficient, and associations of firms, sometimes NGOs, have come in and supplied private rules they've made through a variety of procedures to address these insufficiencies. In some sectors it's about weaknesses in the instruments for parties to contracts. So in the case of derivatives, the International Swaps Deal Association supplies standard terms, essentially, that enable the parties to rely on what they're given in the contracts, relying on them to be enforced in the same way, to interpret the same way in different jurisdictions. In other cases, it's about the credibility of standards. So in the case of food, we see the emergence of international private standards, transnational private standards around food that are concerned with reassuring consumers of the quality or safety of products that they're being given.
And it's a particularly interesting example that you mention, ISDA, in the derivatives markets. At, I suppose, the height of the Greek crisis in 2011, a lot of readers of the financial pages were surprised to learn that this organisation not only existed, it was actually playing a very important role in making decisions over whether Greece had or had not defaulted. There is an element of these private regulators that tend to take people by surprise in a legitimacy or an accountability sense, is there not?
Yeah, in the ISDA case, for a long time ISDA has been saying two things about itself. First of all, it's not a regulator, and second, that to the extent it does set standards, it sets standards for parties to contracts who consensually adopt the standards they set through their master agreement. But what the Greek crisis demonstrated is that the effects of the provisions in the contracts are very widespread indeed, and ISDA has reserved to itself a right to determine the meanings of certain events under the contracts, and that is very significant in its effect not just for a wide range of companies and banks, but also for sovereign debt. And so I think there was a wake-up call around the importance of ISDA, and as you say, it hadn't been previously noted, its centrality to one of the areas of systemic risk that emerged in the 2008 crisis.
Yes, and as you mentioned, the role that ISDA has comes from the agreement as between its members, I suppose a form of private contract, as opposed to any legislative role or any sort of public mandate. Within the EU context, this is a question that EU regulators are getting to grips with, not just in the financial area, but across different areas, is it not?
Yeah, certainly the European Union is giving some thought to the question of what has been previously, I suppose, implicitly delegated through just being no action, to the question, well, can we observe what is going on in particular areas of private regulation? Can we engage in steering, enhancing or co-opting any of that capacity? A well-developed example is in the field of advertising, when the European Commission observed in 2010 that there was a need to regulate online behavioural advertising. They had discussions with the firms involved, the big technology firms, and the firms wanted to regulate themselves. The European Commission wasn't happy. That would represent public interest. Well, the European Commission determined something had to be done, but was happy in the end that the European Advertising Standards Alliance, which is a consortium of national private advertising regulators, would take a lead role, building on the confidence it had created around its activities and the legitimacy of activities in previous interrelationships with the European Commission.
Yes, and that's a very interesting example of how these private associations that do have a regulatory function have a number of constituencies that they have to satisfy as to their credibility. That may be consumers, but also governments. And a very interesting development that's come, I suppose, subsequent to these forms of private regulation is what you describe as meta-regulation.
Yeah, so meta-regulation emerged in literature looking at the role of government in steering and co-opting self-regulatory capacity. And we observed in our research on transnational private regulation that meta-regulation could also emerge as a private phenomenon. So a private meta-regulator is an organisation that steers the self-regulatory or private capacity of other private actors. And we found some very well-developed examples. The reason they've emerged is because across a number of sectors there have been difficulties around private regulation, which is otherwise satisfying the requirements of those involved, where there's something missing that a private meta-regulator can supply. So in the case of labelling for sustainability, the ICEAL Alliance has emerged as a consortium of a number of private labelling schemes, and it's a very well developed example of a meta-regulator setting standards for how private rules are made and then how their impact and effectiveness are evaluated, and these then become conditions for the labelling regimes for their participation and membership of the ICEAL Alliance.
And you've spoken interestingly about how these arrangements where there is something such as ICEAL sitting on top of individual labellers or standard setters, how those individual standard setters then become, in a sense, beholden to each other. I think you might even have used the word hostage to each other in terms of their credibility being collectively on the line as well as individually on the line.
Yeah, the concept emerged in a study by Joe Rees of the US nuclear industry. Following the 3 Mile Island meltdown in 1979, the nuclear industry in the US was up against a wall, and they decided to introduce a powerful self-regulatory regime. And it's proved to be quite effective. And in the study of the industry, Joe Rees called this hostages of each other, reflecting the fact that if one meltdown occurred, probably the entire industry would become destabilised and illegitimate. The labelling schemes have the same problem, that they need credibility of labels in order to be effective in the market. And so their private meta-regulator is not only concerned with giving them appropriate standards for their own regime, but also for providing confidence and assurance around the quality of labelling regimes who are part of the scheme overall.
When we talk about providing confidence and assurance in this field of meta-regulation, it is a task that requires a great deal of capacity, doesn't it? Institutional access. How, or I suppose, what would you point to as an outstanding example of an institution that does that, have that capacity?
Okay, I agree. Meta-regulation does require good capacity. To take the negative side of it first, I think the global financial crisis demonstrated that if there was a problem with the idea of principles-based regulation, it wasn't principles-based regulation itself that was difficulty. It was that the capacity to monitor and make sure that principles were being developed and applied properly was not being rigorously followed through by financial regulators across every state. And so it demonstrates how important that capacity to know what's going on, to understand when to intervene might be. The best developed example, I think, is the ICEAL Alliance. It's worked with its members to work out what's needed to provide that credibility and legitimacy through rigorous standards, putting it back onto the private regulators to state what they're doing, demonstrate effectiveness, impact, and so on.
You've spoken of these developments taking place at a transnational level. Are there identifiable regional approaches which are emerging that diverge from each other, or is this very much functional-based, industry-based, and very much linked up from region to region?
I haven't thought much about the regional issue. There clearly is a strong role for European companies in underpinning some of these transnational regimes, but they emerge in other parts of the world too. They emerge in North America, for example, the case of the Forest Stewardship Council. I'm not sure it's possible to detect at this stage, as I haven't detected any particular regional biases. You might expect to find that because there are different attitudes to self-regulation in different parts of the world. So you'd expect to find more trust in some areas, some regions, less trust in others, and that should be reflected perhaps in the institutional arrangements. It's a question for another research project perhaps.
Yes, and just finally, based on the research that there has so far been into this meta-regulation phenomenon, what are the takeouts, what are the lessons for the policymaker who is seeking to get to grips with these developments, and particularly where the policymaker is sitting there in a national government or even a regional government, but is confronted by developments in markets which are essentially transnational?
I think there's a few different policy implications. The first is that governments should consider what's going on in market-driven governance to see whether there's a possibility of steering it, enhancing it to better fulfil public rewarding objectives. That's one dimension. Clearly the transnational aspect makes it difficult for national governments to act on their own. We've got a well-developed regional governance structure as you have in the EU. It's more straightforward perhaps in that structure to address directly a transnational private regime. I think what the European Commission has been doing to develop communities of practice around self-regulation, co-regulation exemplifies an approach that's about learning more about what's going on, engaging with it, bringing in a wide range of stakeholders to better understand and to use that understanding as a basis for steering perhaps in the future.
Well, Colin, Scott, thank you very much for joining us.
Thank you.